Hi, hello everyone. Welcome to our presentation today on what divorce professionals need to know about estate planning. I'm Shannon McNulty. I'm an estate planning attorney and founder of the Village Law Firm. We protect families, values, and legacies of New Yorkers through estate planning and estate administration. Before we kind of proceed, just an FYI, this presentation is exclusively for informational and educational purposes, and any clients needing personal advice should consult with their lawyer. So I wanted to do this presentation to kind of raise awareness about the interplay of estate planning and divorce. Estate planning is often not thought about as part of divorce, but it really should be, because there is so much overlap between kind of the divorce process and estate planning, marriage and estate planning. There are legal relationships involved in both of them. There are positions of trust that can change before or during divorce. They both deal with money and who ends up with money, who controls the money. They deal with children, kind of who is taking care of the children. Again, money, who's paying for the support of the children, who's controlling that money, as well as future plans for what they want their situation to look like in the future. So when you are working with a client who is contemplating divorce or is going through the divorce process, there are some questions that they should consider. One is, would you want your spouse to inherit your assets? Would you want your spouse to manage the money that you leave to your minor children if you passed away? If you became incapacitated, would you want your spouse to make legal and financial decisions for you? And would you want your spouse to decide if you were to be kept alive on a ventilator? And if you passed away, would you want your spouse to have access to all of the financial information and personal items of yours? If the answer to any of these questions is no, then the client needs to update their estate plan, because otherwise, all of these things are probably not going to end up how the client would want. And in most cases, there are a few cases where it's a very amicable divorce and they keep their power of attorney and healthcare proxy. They want their ex-spouse to kind of have all of those, continue having all of those roles, but in probably 95% of the time, that's not the case, and they don't want their soon-to-be ex-spouse to be involved in those kinds of decisions. So what we're going to go through today, we're going to go through kind of our agenda. I'm going to talk about before divorce, what your clients should be thinking about before divorce is filed, what steps clients can take during divorce, after divorce is filed, to protect themselves and their loved ones, estate planning issues that arise during the divorce process, and estate planning after divorce. And then we're going to talk about an example, which is a real life example of kind of what can go wrong and why estate planning is so important, either during or after divorce. So when a divorce is filed by either of the parties, something called automatic orders go into place. And these orders are kind of to freeze finances and legal issues in place, mostly finances. So they don't want, once a divorce is filed, for either spouse to be taking all of the money out of the bank accounts or making drastic changes, so that it can't end up in the hands of the other spouse. They don't want the tables to be altered or the balance to be altered during the divorce process. So once divorce is filed, there is kind of this automatic orders maintaining things in place. And that means that neither spouse can transfer assets. They can't spend excessively. They can't take on debt, an ordinary debt. And they also cannot change beneficiaries for their life insurance, and they cannot change beneficiaries for their retirement accounts. Um, Importantly, this does not restrict changes to healthcare proxies, powers of attorneys, and wills and revocable trusts. So those things can still be changed, but the beneficiaries for the life insurance and the retirement accounts, which are often things that we work on with estate planning, can not be changed. And by retirement accounts, I mean tax deferred retirement accounts. So 401ks, IRAs, things like that. Um, this may cause your client may want to think about making those changes before they file divorce. That is kind of a tricky subject as to whether you do that. It's kind of a tricky choice because the court may not look kindly, even though legally you can do it, the court may not look kindly if you change the beneficiary to your life insurance right before you file divorce, or change the beneficiary to your retirement account right before you file for divorce. So that's something you're going to want to talk to, or your client is going to want to talk to their divorce attorney about. But in certain situations, it may be warranted. If the other spouse has some kind of addiction or something that's like would be very detrimental if the money ended up in their hands, and it wouldn't be protected for the kids, then that might be something they want to consider. But again, they want to talk to the divorce attorney before making any changes like that. But they certainly can change the healthcare proxy, change powers of attorney, change their will. And that's something I definitely would recommend, because even before they get to the point where they're ready to file for divorce, and if you work with divorcing clients, you probably know, like, it takes quite a while to get to that point. There are a lot of issues that are coming up before the divorce filing. They can put it off for years sometimes. But if there's infidelity, if there's abuse, anything like that, or they just don't trust that person for whatever reason, they may not want that person to be the one who makes decisions about whether they live or die, because those are obviously very heavy and weighty decisions that should only be made by somebody who the client has full trust in. Same with power of attorney. Power of attorney is incredibly powerful. It allows the person who they've designated to have access to their bank accounts, to make legal decisions for them. So if they no longer feel that they can trust their spouse on those matters, then they want to make those changes even before they make the filing for divorce. And that, again, for wills and revocable trusts, so those are things where you're leaving money to somebody. Often, as kind of a default matter, the will leaves everything to the spouse, and the spouse is designated as the executor. The client might not want that to be the case anymore. So they can change that so that the assets go to their children or to somebody else who they would prefer to have the assets rather than their spouse. Absent a prenuptial agreement or postnuptial agreement, the spouse does still have access to 1/3, or the right to 1/3 of their spouse's assets if the spouse passes away, if they're still married. So that's not something that can really be changed. But still, that's 1/3 rather than 100%. Okay, so during divorce, once divorce is filed, then divorce can take a very long time. Sometimes it's quicker, but in a lot of cases, it's very rare, I think, to see a divorce last less than 1 year. But many times it's many years. And so during this whole process, which can be incredibly stressful and difficult for both spouses, there is no effect on the estate plan. So there's no effect on the wills, powers of attorney, healthcare proxies. Those are not revoked upon the filing of divorce. They're only revoked upon a final order of divorce. So I think this is something that is often misunderstood, that, okay, I filed for divorce, so I don't have to worry about changing my will or any of these things. My spouse wouldn't be the beneficiary of those items. That's not the case. They have to affirmatively change those documents. So during divorce, the client should review their estate documents. Are assets left to the spouse? Is the spouse named as the executor in the will? Is the spouse named as a healthcare proxy or power of attorney? And if they don't want their spouse in those roles, then they should update those documents. If the client doesn't have a will, then the spouse may be entitled to everything. If there's no minor children, the spouse gets everything. If there is no will, the spouse always has priority to serve as administrator of their spouse's estate. And that means that they would be in charge of and have access to all of the spouse's financial information and assets and all of their personal items as well. So if you're the executor or administrator of an estate, you have the right to go through that person's apartment, go through all of that person's information, their personal information, their financial information. And that could be very considered a violation of privacy, that they don't want the divorcing spouse to have access to that kind of information. Also, the spouse would be in charge of managing assets left to a minor child. So even if the assets all go to, for example, in New York State, if you are married and have kids, about half of the assets go to your minor children and half of the assets go to your spouse. The assets that go to your minor child, somebody has to manage those assets, because a 3-year-old or a 5-year-old or a 10-year-old, they're not legally capable of managing assets. So what happens is the court would appoint somebody to oversee those assets, and it's generally going to be that child's parent. So the spouse, even if they're not entitled to everything, they would basically be in charge of the money that's left to a minor child. In the absence of a healthcare proxy, a spouse has the default authority to make medical decisions. So even if there is no documentation, they by default would have priority to make that kind of a decision about life or death decisions. And like I said before, even if the will cuts the spouse out, the spouse is still entitled to 1/3 of the estate. And I should mention, actually, if you have any questions while we're going through, feel free to put them in the chat or the Q&A, but we'll also be taking questions at the end. Okay, so what can clients do before divorce is final? So if they are going through the divorce, they should update these documents: their healthcare proxy, power of attorney, their will, or their trust, their revocable living trust. And this is the same as kind of the documents that can be changed upon the filing of a divorce. So even though they can't change the beneficiaries of retirement accounts, so they still can't do that during divorce, they can't change the life insurance beneficiaries, they can update these documents and make those important changes. So during divorce, other issues can come into play, and there may be estate planning that has been done prior to the divorce where it can't be changed. So irrevocable life insurance trusts, family partnership trusts, these are things that are structures that are often put in place for estate tax purposes, Other types of trusts are QPERTs, qualified personal residence trusts. Those things are hard to unwind. And so during the divorce, these things have to be negotiated. And there are generally ways that those can be negotiated and by disclaimers or some other way, but generally an estate planning attorney would need to be involved in those decisions. They should be involved because those are very complex tax planning documents. So in order to be able to change those or alter them in any way, then it really needs to have an estate planning lawyer to be involved in that. But it's important to understand that usually those things can, some and often can be able to be changed. But it may be not be that straightforward. It can be pretty complex. Other issues that come into play, other estate planning issues that come into play during divorce are third-party trusts. This means a trust that is set up by somebody other than the spouses. So, for example, a parent of one of the spouses may have set up a trust and left money to their child. There is often a question of whether this is an available resource to the child for a divorce, for considering equitable division of the assets. And generally, those are not considered an available resource, but it does depend on how the trusts are administered and the terms of the trust. So those are things also that probably an estate planning lawyer would need to be involved in. There also, in terms of when clients are or spouses are agreeing to a divorce settlement, there may be requirements in that settlement agreement that certain things be left to the spouse or to the children in wills, through life insurance, through trusts. And one thing that I noticed is that often these agreements are not very clear with respect to what exactly is required. So they'll just say the life insurance has to be held by a trust for the children, and it doesn't specify what the terms of that trust are. There's lots of different types of trusts. There are many, many ways that those trusts can be structured. So if you are advising a client on including estate planning provisions in their divorce agreement, you want to make sure that those are clearly laid out and probably consult with an estate planning lawyer on what that should look like. And also, how is that going to be enforced? So if you want a certain amount left through a will, what if there's not that much, there aren't any assets or there's not assets sufficient in the estate to fulfill that requirement? Then there's not really any recourse for the other spouse. So in these cases, you often want to require life insurance to be able to fund that bequest, to make sure that there's money there to be able to fund the amount that's promised in the agreement. And it should be an irrevocable trust, the life insurance, or the other spouse should be the owner of the insurance. So those have to be structured. They should be really structured really tightly. So to make sure that that money would be paid out and that life insurance policy is in effect. So many times I've seen, okay, this is the divorce agreement, and it requires life insurance to be purchased and put into a trust or not put into a trust. The policy is never purchased. So they sign the document and that is never purchased. And there's not really a whole lot of recourse, again, if somebody passes away and that has not actually, the life insurance hasn't been purchased. If there's not enough assets in their estate, then they're kind of out of luck with respect to what was required in the agreement or what they would be entitled to. So it's really important after the divorce agreement has been finalized and order of divorce put into place to make sure to follow up with the other party, the other spouse, to make sure that the life insurance for your client is put in place so that they wouldn't be out of luck if the other spouse, the former spouse passes away and now they can't pay the alimony, there's no alimony, there's no child support, what would happen in that situation? It could be really bad. So you want to make sure that that life insurance is in place to protect your own client. Okay, and so these are other estate planning considerations after divorce. So after divorce is final, there's a final order of divorce by the court. There is an automatic revocation of certain estate planning documents. So in wills, powers of attorney, healthcare proxies, a spouse is treated as if they had predeceased. So it would take effect as if the spouse had predeceased, and the next person listed would either be appointed as the executor or receive the bequest, whatever was be going to that spouse. The same is true for revocable trusts and for most beneficiary designations. So beneficiary designations on life insurance, automatically, again, that spouse is treated as if they predeceased and it would go to the secondary beneficiary. But really important is that ERISA retirement account beneficiaries are not automatically revoked. So even if you go through a divorce, you have a final order, your 401k, IRA, those things, if you don't change those, then whatever is on that account as the beneficiary, whoever's on that account, is going to inherit it. And so even if it's a former spouse, they are going to end up with the assets. And that unfortunately happens more often than you would like to think. And it's obviously can be very devastating for the other family members. You still want to update the beneficiary designations, even if they're automatically revoked. Still want to update those because you're going to want to put a secondary person there as well. Also update all of your other estate planning documents to the extent that they don't reflect what your wishes, your client's wishes are. Usually, especially when clients have minor children, I recommend that they leave the assets they have a revocable living trust that avoids probate and minimizes the chance for an objection by the former spouse or interference by the former spouse. It keeps things much more private. And then you, of course, want to execute those estate planning provisions in a divorce agreement, like wills, life insurance, and trusts. Other things for estate planning considerations after divorce, if there are minor children, you definitely want to leave the assets to a trust for the child. Otherwise, any assets that are left to a trust that are left to your children, left to minor children, the court will oversee those assets until the child turns 18, and generally they're going to appoint the child's other parents, meaning the former spouse, as the guardian of the assets, meaning that the ex-spouse would be managing that money for the children and deciding how it's used. The custody of minor children, this is a question that I get a lot, and even if your client has sole custody, if they pass away, the custody is generally going to go to the child's other parent. And short of documented abuse, physical abuse, substance abuse, those kinds of things, there's not a whole lot of evidence, or there's not going to be a whole lot of likelihood that the children would end up with somebody other than their parent. If there are cases where there is that kind of an abuse or neglect or substance abuse where you feel like the child would really be in danger, then you want to make sure that the client has documented that and that those documents are available to in case they passed away, and that whoever they would want to appoint a guardian, designate a guardian in their will, and they would want to make sure that that guardian has access to all of the documents that evidence the abuse. because they will need to, that person will basically need to fight for the children. And parents with minor children, they're really vulnerable without a will. Like I said, the ex-spouse is generally appointed to manage the children's inheritance. And also, the former spouse has the right to serve as the administrator of the estate. This is even after divorce, that the ex-spouse is able to serve as the administrator of the estate, meaning that they are the one who's in the position of gathering all of the assets and having access to all of their ex-spouse's information and assets and personal items. I have a question. What is if there's an abandonment or estrangement for over 5 years? So generally, even if, and I assume this is for a child in terms of the custody of the child, there's still that other parent is generally, unless their parental rights have been terminated, they still are going to have the first right to the child. There's not even a proceeding unless somebody else is basically brings a proceeding saying that they're not fit to care for the child. And in that case, then the judge would have to make a determination. It's an uphill battle, but it does happen. Okay, so I'm going to talk about an example. This is an example that we've actually seen, and that kind of illustrates what the downsides are of not planning and kind of like how it can end up in a not great scenario pretty easily. So in this example, obviously everything is changed here for purposes of privacy. But this is kind of an example that's based on basically a real life situation that we've seen and that basically would happen if in this type of circumstance. So here in this example, Jane has we have a woman, she has a 3-year-old daughter, Leah. Jane got divorced from Leah's dad, John, a year ago because he refused to get a job. He hardly ever helped out at the house, and basically she was just taking care of everything, and she got fed up and said, I don't want this anymore, and they went their separate ways, and they got a final divorce. Okay, Jane never put any estate planning documents in place, and she got into a car accident at the age of 37. She had no will or any other estate planning documents, and she passed away. So what happens to Jane's assets? So first of all, in terms of custody, this is the question that had come up before, but John would have sole custody of Leah. And even if he wasn't, in terms of like legally unfit, maybe he just wasn't really a very good dad because he really wasn't helping out or taking care of Leah anyway. All of Jane's assets would go to Leah, but the court appoints John to manage the assets for Leah until she turns 18. So this is the person who was not at all helpful and was not great with money, and now he's the one who's managing the assets for the child. And to make things even worse, Jane's mother wanted to manage the assets for Leah, but couldn't do that without John's consent, which he refused. The mother was not even allowed to be the administrator of the estate. So she really didn't want John to have access to all of Jane's personal information, but he wouldn't agree to let her serve as the administrator. So she was really upset that basically it was kind of resulting in a violation, is what she felt as a violation of her daughter's privacy. So what ended up was Jane's assets were left in John's hands to manage for Leah, the guy who was terrible with money, refused to get a job. And on top of that, as the administrator of the estate, he gets paid a pretty hefty fee to manage all Jane's estate and going through all of her personal items. So this is like a pretty awful scenario. It's a pretty awful outcome. But it's not that uncommon in the sense that this is not an uncommon situation, right? You have a divorce that's not great. One spouse is kind of a little bit is neglectful, and the the client doesn't update their documents. They don't do an estate plan, and of course, none of us know what would happen. Kind of like what's going to happen. Um, and when our time is up, and unfortunately sometimes it's at a time when you don't expect, and you don't have things in place and it's not planned for. So kind of the overall message here or lesson, I think, is don't let your clients be Jane. You don't want your clients to their kids or their loved ones to kind of end up in this kind of a situation. So really, it's pretty simple to avoid it. Just want to make sure they have their basic documents in place. I do recommend that if they have young kids, that they do a trust as well, but it's nothing that has to be particularly complicated. Um, so that's kind of an overall, and just try to keep it pretty simple in terms of uh, what the issues are. But if anybody has any questions, please feel free to put them in the chat or put them in the Q&A or raise your hand. I'm not sure if you can do that. And hopefully this was helpful. I know it's kind of a higher level overview, but some of these things are just not thought about very often. Okay, if you have a will and a healthcare proxy, do you need a trust? So it really depends whether what county you're in. So that sounds strange, but if you have a will and you don't have a trust, everything goes through probate. In Nassau County, that's probably not going to be great, but it kind of depends also on when it happens. So we saw during COVID that all of the counties were really backed up, and some of them are still backed up, and it was taking like 2 years to get anything done. So it could end up that the money isn't available. If the money doesn't need to be available immediately, it might not be a problem, but they kind of want to ask themselves, like, are there bills that would need to be paid, like a mortgage or something like that? If you have young kids, definitely I would recommend a trust, because there's a lot of expenses that would need to be paid immediately. Also, a trust is less likely to be interfered with. So if you leave a will, then there's a lot of opportunity for unhappy people to object to that. So a lot of times I do recommend, especially if there are minor children, for the client to do a revocable trust. And the revocable trust, just for those of you who might not know, it's just a way to avoid the probate systems and the court systems. So when you pass away, the assets, the people who are dealing with your assets, they don't need to wait for the court to do anything. They kind of automatically, almost immediately, have access to the assets and can manage things. So it can be a lot more seamless. For them, it's definitely a better way of setting it up, but it really depends on the client's situation, their budget. If they're only adult beneficiaries and they're okay leaving things outright to them, then they could maybe avoid probate by just naming a beneficiary on accounts. So there are ways that you can still avoid probate, but it kind of depends on the client situation. Hi, Tracy. Is it possible to use that example, but assume she passed away prior to divorce being final? What would the difference be with her assets? So in New York, the custody would be the same. The difference is that if she were still married, half of the money, and she didn't have a will, half of her money would go to John, and half of the money would go to Leah, and John would still manage that money for Leah, but half of it would go outright to John. Okay, so those were great questions, and I don't think there's anything else, but if anyone has questions afterwards that come up, or if you're working with a client and you just want to get my thoughts on something, feel free to reach out. And I'm glad that you all were able to join us, and we'll be sending the recording of this presentation subsequently. So if there's anything that you want to revisit, you should be able to. Okay, thank you so much and have a wonderful day.